Welcome to Afternoon Light, the podcast of the Robert Menzies Institute, hosted by Georgina Downer. How should we interpret a constitution, which is, after all, not a detailed statute, but a frame of government? Should we interpret it as if it were an ordinary act of Congress or of Parliament? That is to say, narrowly and literally. I do not think that anybody nowadays would support this idea of constitutional interpretation. Should we interpret the words loosely and politically, that is to say, responding to the varying currents of political opinion? If so, interpretations will tend to fluctuate according to the political complexion of the judges. The Constitution must have an authority of its own. Now, these were the words of Robert Gordon Menzies in 1967 when he gave a lecture at the University of Virginia on central powers in the Australian Commonwealth. Constitutional interpretation is a vexed and often politicised issue, not just in Australia, but in other jurisdictions like the United States. Joining me to discuss the US context and its history is Justice Amul Thapar, Judge of the United States Court of Appeals for the Sixth Circuit. Welcome to Afternoon Light, Judge.
Thank you very much. Thanks for having me. It's quite an honor to be here at the Menzies Institute.
It's an honour for us to have you here and our first American guest, so that is very exciting. I'm fresh off the plane from the United States, so full of all the great ideas and goings on there. And no, it's wonderful to have someone like you on the podcast to discuss what is a really important issue, and obviously an issue that Robert Menzies himself grappled with, having been both a lawyer, a barrister, and then Prime Minister, a leader of government. He saw sort of both sides of how constitutional interpretation can have such an impact on our lives. But Judge, you've written a biography of one of the US Supreme Court justices, the longest serving one, the oldest one, and he's quite a figure in his own right for many other reasons too, Clarence Thomas. And he's very much known as the symbol of constitutional conservatism on the US Supreme Court and also original interpretation of the US Constitution. For our listeners who aren't legally trained and follow these issues, can you tell me what is originalism?
Yeah, so the book itself, and let me start with that since you brought it up, the book itself called The People's Justice is really about 12 cases that came in front of the Supreme Court and explains the story of originalism. So that's different than the theory of originalism, and I'm happy to explain both of them. But first and foremost, let's start with the theory of originalism because that's what you asked about. The idea behind originalism is that judges interpret the law consistent with the way it was approved and passed. And what I mean by that is the best example I can give for just an easy way of thinking about it, not a perfect analogy, but an easy way of thinking about it, is the American Constitution is a contract between the American people and the government. And the idea was if the American people were going to allow the government to infringe upon their God-given rights, they were going to do so in a very limited fashion under the deal they set and the parameters they allowed. And that's what the federal United States Constitution does. And so it is a judge's job to interpret that consistent with the meaning of the document as understood at the time it was approved. So the analogy back to a contract is if two people sign a contract, they reach a meeting of the minds, and that meeting of the minds is reflected in the terms of the document. And if they come in front of a judge, it's the judge's job to try to figure out what that meeting of the minds reflects by interpreting the terms in the document. So if they're resolving a dispute, they'll resolve it according to the terms the parties themselves set versus what the judge thinks is best for them.
Yeah, and why is that important to ensure that the Constitution is interpreted in that original meaning? Because there are obviously other forms of judicial interpretation, constitutional interpretation. The particular one, I guess, on the other side of the coin is the living Constitution. So you sort of evolve as society changes and it sort of reflects the kind of mores of the day. But the originalist view is linked to something that's struck in the 18th century. It's a pretty different society from today.
So the way I think of it, look, I'm not perfect. People will say I'm right or wrong depending on their viewpoint. But there's really three strains of thought in America today as to how to do judicial interpretation. There's living constitutionalism on the what you can call liberal or progressive side. There's living constitutionalism on the conservative side. And then there's legal interpretation is what I think of as originalism. We don't reach conservative or liberal results. We reach legal results. Now, we've been accused, I think improperly, and the book proves that this is wrong, of reaching all conservative results, but that's not true, as any educated person of the court would know. And if you just read the 12 chapters in the book, there are 12 different stories of 12 different cases showing that originalism leads to results that ultimately reflect the will of the people at the time. Now, of course, what that means is people often say, well, originalism is wooden because it won't allow you to do living constitutionalism and adapt the Constitution to today. But when you do that, you change our country from a republic to a dictatorship run by judges. In other words, if I can prescribe what's in the Constitution, I have replaced the American people. And remember, people often say, well, then how are we going to get more rights? How are we going to adapt to today? I recognize passing a constitutional amendment is extremely difficult, but the founders made it difficult for a reason. And if it's that difficult, should a judge really be able to do it with the stroke of a pen? And so the way people pass protections today, most often in the United States, is through their elected representatives. They pass laws. So the Civil Rights Act is one of the great ones in the United States. That is not in the Constitution. That was passed by Congress and signed into law by the president. Similarly, states in our country can pass laws. Cities can pass rules and regulations and laws. And so you have different entities that can accomplish at a local level what the local people need. And what the people in Kentucky need is different than what the people in California need, which is different than what the people in New York need or Florida. And so it allows the states, just like you have states here in Australia, which are closer to the people that live in that region than the federal government, to pass things that protect them.
Yeah. Taking the originalist approach, you obviously need to have a very good understanding of US history, US constitutional history, and what was going on at the time, the debates of the time, the intention of the drafters of a constitution. So, I mean, do you see judges arming themselves with an appreciation of history in order to undertake these cases and decide these cases? Because that surely is fundamental.
Yeah. So the fun thing about the book, The People's Justice, is when you read it, you not only learn about the cases and the drama behind the cases, the human drama, the real human drama that goes in. And Clarence Thomas never forgets there's real people in every case. But you learn a little bit of American history and world history because we study English law to understand what came before us, to understand what we were doing when we were setting up our country, because some of the things were set up very intentionally to prevent what was happening to us when the empire ruled us.
Yes.
Right?
Yeah.
And so...
And you're looking at the French Revolution and, you know,
we
there are
look at
all these
kinds
sort
of things.
Yeah, all these really major global events that were taking place when the US Constitution was drafted and your Bill of Rights.
Right. But here's the thing, is we're not alone. We have professors doing it. We have lawyers doing it, right? So one of the unique things about the American Constitution, it may be true in other countries, but is that all judges do is resolve cases or controversies. That's what Article 3 of our Constitution says. That's the judicial power. And so we're just resolving that discrete case in front of us.
Yeah.
And so we don't have to reinvent the wheel every time. In fact, 90% of the cases I decide, there's precedent, there's other things that we just simply follow. Now, it's not always easy. I mean, we do work to follow it. We figure out how it applies in the particular circumstances. But the question is, judges are equipped to study history and reach a legal result as a result of the understanding of the terms. The question everyone should ask themselves is, the alternative is that I am equipped to figure out evolving standards of decency or things like that. or reasonable expectation of privacy, as our Katz case says. Someone's reasonable expectation of privacy. Well, what I think is a reasonable expectation of privacy is much different than what you may think or someone else may think.
An 80-year-old will have a different view of a 20-year-old, who's used to having everything on social media, and an 80-year-old's like, no.
It's funny you bring that up, because whenever I go to schools or talk to students and they say, well, why not? I say, well, do you really want me deciding what your privacy rights are? Because you have a much different view of that device in your pocket than I do.
Yeah. I think that's quite a stark example. So tell me, Judge, what was that vision of America that the Constitution framers had in mind that I guess frames originalism?
Yeah, so when the Constitution was being ratified, Brutus, a famous anti-federalist, so the anti-federalists were against the Constitution, but they ultimately wanted a Bill of Rights. They wanted some things like that. But Brutus, in his 15th letter, talks about his concern that judges would rule consistent with the spirit of the Constitution versus the letter of the law. And he says that soon judges will find that they're not even below the Constitution, and ultimately they'll find they're not even below God himself if they get to this point. And Hamilton, who's now famous thanks to the musical. Yeah,
he's a great rapper.
That's right. Hamilton, in response, in a paper that's pretty famous called Federalist 78, responds and says, no, it's the judge's job to rule consistent with the terms and meaning as they're understood, not the spirit of the Constitution. And that's where he has some famous lines where he talks about that we only have reason. We don't have force. We don't have a military force that can enforce our decisions. And so our reasoning has to make sense or no one will obey it.
And because the idea of the spirit of the Constitution gives too much, I guess, ability to the judges to kind of freelance then.
Yes, it's living constitutionalism, I think. Yeah. But look, my friends who are living constitutionalists would say, no. We too are constrained. But I'm not sure I understand what their constraining principle is. Now, to be fair, I'm not a living constitutionalist, so I haven't thought deeply about how to set constraining principles. There is a good book for those that want to consider living constitutionalism by David Strauss. He's a professor in the United States. I think it's called, I'm going to mess it up and I apologize to the professor, but it's like Common Law Living Constitutionalism. And what he tries to say is the common law, which is what historical jurisdictions used to be, we're more of a statutory and constitutional law jurisdiction, I would think, than a common law. But he is trying to make the argument, and I think he does a pretty good job, that the constraining principle would be the traditional principles of common law. In other words, you can only evolve it consistent with that which came before you.
Yeah, right. Okay. Well, which, is very much the system we have in Australia, and it shouldn't be that controversial. But when it comes to the Constitution, as you said, it's this contract between the people and the government, and the people are saying, well, we're prepared to be constrained. And this was in a period when there was a lot of concern about government encroaching on rights, which really colours of American experience. And you find that Australians are much less averse to government encroachment in their rights than the American public is.
Yeah, I think we saw that play out during COVID.
Yeah.
For example, the American people pride themselves on liberty.
Yes.
Right? It is the reason our country was founded in many reasons, to get liberty from the crown.
Yeah.
And so I think that might be different, but I think you should pay attention. I think when people read The People's Justice and see the stories of the people, and you'll get a real taste for what not only American law is, but how government can encroach and how that really bothers the American people, left, right, and center, right? There's not many things the American people agree on, but liberty is one of them.
Yeah, I know it's entirely different kind of political foundation than Australia. We start from a very different place, and I think Australians need to remind ourselves of that when looking at the US context. We can't translate our sort of society and values straight neatly onto the US context because, your commitment to liberty is foundational.
It's in the document.
Yeah. But your constitution is an 18th century document, and there are, from an Australian perspective, we look at, say, the right to bear arms. It's always the one that confounds Australians because we think, we basically banned firearms, semi-automatic, automatic weapons. So we had a terrible tragedy in the late 1990s at Port Arthur in Tasmania. That's sort of impossible in the US. It's in your constitution. Critics of originalism would say, well, you've got to look at the 21st century and some of the clauses that were adopted in the 18th century just are not fit for purpose for today. Is there a sense that the Constitution is outdated?
Not at all. It's the brilliance of our founders. It's the brilliance of the document. So when people say, well, how could the founders have envisioned the internet? Or how could the founders have envisioned modern technology? Yeah. Well, that's why they use the terms they use. So if you think of freedom of speech, when you figure out what it means, which is, there's a rather intuition to freedom of speech, right? And you think about the internet, if I am writing, I always tell kids this because they like this. We're not allowed to have the app on government devices. So I don't have it. I tell my kids when they send me these TikTok videos, I'm like, I can't watch them. Stop sending them to me. But TikTok, when a kid gets on TikTok and gives a speech, or an adult or a person, that's speech.
Yeah.
It doesn't matter. The medium may change, whether it's a newspaper or TikTok or a tweet or an X, whatever you call it today. It's still speech. And if the government is using infrared technology instead of walking through your home, they're still searching your home. And so it's the brilliance of the document and that the terms they used apply today.
Yeah, well, no, that's a very fair point. Do you think that the Bill of Rights, we of course don't have a Bill of Rights in Australia, and Robert Menzies, he was opposed to moves to introduce one. He saw that as unnecessary in the Australian context and giving too much power to unelected judges. So he had all the arguments against it. But you have a Bill of Rights. How effective has it been in protecting freedom, which is obviously your liberty is so fiercely protected by the individual in the United States, but does the Bill of Rights support that?
We don't know any different. So it's an interesting debate that you're having in Australia. We had it at our founding.
Yeah.
The Anti-Federalists would not agree to the Constitution without a Bill of Rights, and James Madison and others promised them a Bill of Rights, and James Madison came through on his promise 2 years after the Constitution was ratified. I think judges don't know any differently, and we value and treasure the Constitution as a whole, including our Bill of Rights. It's really one document.
Yeah.
And I think it'd be much different if we were trying to pass a Bill of Rights today. I think the American people would be very worried in many respects because we're so divergent. America today is a 50-50 society in many ways. 50% see the country one way and 50% see it another. At its core, it's not that. And I have a firm and healthy confidence in the American people, and that when push comes to shove, they can work together to accomplish great things. But while we're comfortable, we can debate the issues of the day, right? And I think everyone in America finds it comfortable debating, or not everyone, I should say, I can't speak for everyone, but they find it comfortable debating and passing laws and fighting about it through the laws versus the Constitution. And so rather than amending or rewriting the Constitution, what we do is we pass laws that protect rights or allow the government to do certain things. And I think that's important. I think that's the way to go, at least now. I'd be shocked if we ever revisit our Constitution. And I think the Bill of Rights everyone in America has grown up with, is used to. And if you tried to take it away from us, we'd probably fight a war.
Yeah, well, yes, it seems part of your DNA. But it does open up the ability of certain more activist judges to really push their own point of view of what is the quality of a right. And, of course, the right to an abortion was a very pertinent issue, wasn't it, for both sides of the political divide in the US.
And we're seeing that play out the way that I'm talking about, in the sense that now the states are passing laws related to abortion, since It wasn't in the Constitution. The Supreme Court said it isn't in the Constitution. And now you're seeing it play out state by state. And that's what I'm talking about. But at the end of the day, right, the Bill of Rights, the amendments to the Constitution that give the American people rights, because when we talk about the Bill of Rights, we're really talking about the first 10 amendments, but you can't leave out the Reconstruction amendments, which are the 13th, 14th, and 15th, which ridded America of that horrible history involving slavery that you all didn't have to deal with, and allowed for the Equal Protection Clause and other things that Americans hold so dear. But all of that is rooted in our belief in liberty, right? Our Bill of Rights are really ways we protect ourselves from the government. Remember, the Bill of Rights protects the individual from the government. And so it's very different than what you have in Australia as we go back to discussing liberty, is most of what we have comes from liberty. And so now today in the abortion debate, that's the debate you're having, is whose liberty, whose right to life, right? These are the two sides of the divide, and judges don't get involved in that. We leave that to the American people. And that's where originalists think a lot of these debates belong.
The Bill of Rights, though, does it open America up to being a more litigious society than, say, Australia, where we don't have a Bill of Rights? Or is it, I mean, it's hard to say because you've had it for so long. So, like, well, in that alternative reality where we didn't have a Bill of Rights, maybe we would. Like, is there more kind of pitting against the government? I mean, we don't see that phenomenon in Australia where people are regularly taking cases to the High Court over what's happening to them as an individual, trying to protect their rights.
We're very protective of our individual rights in America.
And that Bill of Rights, does that set the, I guess, the scene for that?
It does. And I mean, I really would encourage people here that are curious to read The People's Justice, because you'll get a real feel for the American culture, but also the American view of their rights, right? When you go to a school, like you go talk to young people, that's what they know about. They may not know about the structure of government, which is more important than the Bill of Rights. As Justice Scalia used to say, any crackpot dictator can have a Bill of Rights. North Korea has one of the best Bill of Rights, but it's the structure of the American government that really protects your rights. I think that's true in Australia. Like, whether you need a Bill of Rights is kind of beside the point. It's the structure of government you all have, the pride in checks and balances, an independent judiciary, all of those things that really protect the Australian people. And so for you now, a Bill of Rights is much different than a Bill of Rights at your founding.
Yeah. I mean, it is fundamentally about the strength of your institutions, and, of course, trust in government and trust in the judiciary and trust in the legislature are fundamental to that. We don't have such a politicized selection of judiciary. It's a very different process here. The sense we get from Australia looking at the US context is these Supreme Court judges or the nominees are before Congress and committees and having to basically defend themselves and asked all these hypothetical questions, and then there's usually some terrible scandal uncovered, and then there are sort of testimonials, and it's all, I mean, it's heavily politicized. I mean, our judges are basically unknown and uncontroversial. Tell me, is it because of the fact that rights are so important to an American and that rights are so fiercely defended that then makes the role of the judiciary inherently political or politicized?
Well, I can tell you one thing, that we judges in America, 100% of us, wish we didn't have confirmation hearings because we do view it. Yeah. For judges, I think Justice Ginsburg kind of said it best when she said, I can't give you what you want. I'm simplifying. She said it much more eloquently, but I can't give you what you want because as a judge, I can't forecast what I'm going to do. That wouldn't be fair to the parties that ultimately might come before me.
Yeah.
And what politicians want uniformly is for judges to tell them what they're going to do in future cases.
Yeah, they want assurances.
Right. Yeah. And what we can't give is what they want. So the hearings are a zero-sum game.
Yeah.
So I can tell you with complete confidence that I speak for almost all of my colleagues that we would be perfectly happy if you nominated us based upon our qualifications and confirmed us based upon our qualifications. And it's funny because the judiciary, I think, in many ways, is the best we have to offer, in that I have this wonderful court of judges who are appointed by everyone from Bill Clinton, right? The active ones. We even have ones that were appointed before them, but the active judges from Bill Clinton to Joe Biden, right? So you have Clinton, Bush, Obama, Trump, Biden nominees on our court, and we all get along and we agree. Here's the startling thing for the public, but not for judges. We agree in 90 to 95% of our cases, despite the fact that I think what the politicians think is we always disagree, and what the media portrays is that we're always disagreeing. We rarely disagree. We work to do law, and that is something we're all equipped to do. And I think we do it rather well, and I'm very good friends with people that think very differently than me on my court. And that's the level of civility and friendship and kindness that exists on my court, I wish was modeled in society today.
I mean, it's a huge challenge, but as you say, the media and the confirmation process play into this sort of idea that judiciary is sort of wrought with political division and antagonism. But
look at the Supreme Court. And when you see in the People's Justice, Justice Thomas, who comes, as you said at the outset, is perceived, I'm not going to say is perceived as conservative. He is an originalist. He's perceived as conservative. But when you see how many times there's strange bedfellows, and what I mean by that is there's strange alignments of the justices, if that was reported more accurately and more often, it'd be really hard to say the court is quote unquote political when 90% of their decisions, or 80% of their decisions, between 80 and 90% of their decisions, they don't line up like everyone's reporting, and they only report on that small segment where they do.
Well, the others won't sell newspapers. Well, not that newspapers sell anymore, but they won't produce clicks.
Right. You can't blame the media or the click masters, but I'm just telling you the reality.
Yeah, no, it's very interesting. Do you think that the Supreme Court particularly became, well, at least from the outsider's point of view, it became more politicized with Roe v. Wade? I mean, was that just a point where people started to really focus in on there's two divergent points of view and it's activist, it's creating these rights that just clearly didn't exist?
I think it's unfair to say it became more political. In the 50s and 60s, Justice Scalia believed it became more activist.
Right.
Okay. And then Justice Scalia, Justice Rehnquist, Judge Bork, Ed Meese, others in our history brought us back to being an originalist court. We were pretty much throughout our history, I would make the argument, an originalist court. We hit the 50s and 60s, it became a more activist court.
And that was because of the appointees at the time, or was it the political moment? The 50s and 60s, it's Cold War. 60s, obviously, there are massive divisions in US society, riots over the Vietnam War, civil rights movement, assassination, Martin Luther King, JFK. I mean, it's a big decade for
and Bobby
States.
Kennedy.
And Bobby Kennedy, of course. Yeah.
No, I think there was a lot going on. And so it's hard for me.
I'm glad I kind of missed it. Being born at the end of the 70s.
Well, and I missed it being born at the end of the 60s. So I guess you're younger than me, but I too missed it. And so what I can say is that was just a different time. And I can't say it's because of the appointees. I can't say it's because of the time. I can say maybe it's a combination, but I don't know. But what I do know is that before and after that, we've been more tied to a reasonable construction of the law as it was understood.
Yeah.
We don't say strict construction like you pointed out at the beginning maybe, and we don't say loose construction, we say reasonable construction, right?
Yeah.
And so I can tell you what happened before and after. I can tell you what happened during that period. The why is a harder question, and I don't think it's fair for me to answer that because I think that's putting myself in the minds of the justices at the time, and I can't do that.
Yeah, no, that's fair. That's fair. I'd like to talk a bit more about Justice Thomas. He's quite an extraordinary individual. He is obviously a person of colour and has been on the court since 91, which is incredible. And of course, the Supreme Court judges stay on until death. So he's there until God decides he's not.
Well, they can retire.
They can retire, yeah,
Right.
but have tended not to.
Some have.
Yeah.
Justice Breyer recently retired, was replaced by Justice Jackson. And so it definitely happens. I'd say most retire, but yeah, our recent history might say otherwise.
Yeah. But he's sort of coming up through the civil rights movement in the 60s. I understand he even had a Black Panther poster in his dormitory. Is that right? In the dormitory room. Yes. There's a kind of connection with that very hardcore arm of the civil rights movement. But he has, through his career, been quite an opponent of identity politics and being identified as a black man, as that is sort of who he is. He wants people to be seen as an individual and not just defined by race. And he has been really very harshly criticised for being sort of a race traitor in some respects. And I just wondered if you could talk me through, why is it that people like Justice Thomas have to defend a corner when they are there for their incredible legal mind, their achievements? The president of the day has obviously put huge trust in that nominee to take this incredibly important position in the US judicial system. And yet others will say, well, you're there because of your identity and you need to be a defender of that forevermore.
One of the things I discovered in writing The People's Justice, and you'll see this when you read it, is that Justice Thomas, while the preeminent originalist, and so the best way to tell the story of originalism is through Justice Thomas's eyes, because everyone believes that he is an originalist no matter what. He never compromises those principles.
Right, yeah.
But what I learned about him is he's not only someone who cares deeply about people, hence the name The People's Justice, but he's also has this very strong black voice, a black nationalist type voice. So he's never really lost. That it's just not accurately reported. But if you read the cases and read his own words, he often quotes Frederick Douglass, a role model for him. He often quotes, the second chapter is called Education Means Emancipation, because Justice Thomas quotes Frederick Douglass in that chapter about the poor and minorities. That's a chapter about poor people getting vouchers so they can get out of failing schools. And it tells the story of these kids and the horrific conditions they were in Cleveland, Ohio, and Ohio's attempt to give them a voucher and let them go to non-failing schools, and the fight against that by the teachers union and others to keep them in these failing schools. And Justice Thomas's strong opinion talking about how only the elites would dream of everyone having universal public education when they're failing poor and minority kids. And the reality is, it's until they fix it, we have to give these kids, this generation, we can't sacrifice a generation for the elite standards that people who won't send their kids to these schools are set.
But how did he link that back to originalism then? I mean, the intention of the founding fathers, though, was...
So you got to read the book, but the second chapter is about the challenge that if you use a voucher for a religious school, you're violating the Establishment Clause. And Justice Thomas has a great line.
And you should explain to our listeners the Establishment Clause.
So the Establishment Clause, when you will remember that England had the church.
Yes, official state church, Church of England.
The Church of England. Yeah. And we did not want the Church of the United States of America. We did not want the federal government having a church. But at the time the Constitution was ratified, several states had a church. And Justice Thomas points this out, and he says that these are individual liberties, but one thing we stuck in there is preventing the federal government from having a church. Mm-hmm. So what did the voucher program do? The voucher program gave money to parents, poor parents and minority, also poor white parents, anyone in inner city Cleveland who couldn't afford to send their kid to private school. It gave them the opportunity to go to a different public school, to get tutoring, or to use it to go to a private school.
Right, yeah.
And the Catholic schools were willing to participate in the voucher program, even though it was much cheaper than going to that school, basically. And so the parents could use the voucher to go to the Catholic school. They challenged it and said that's a violation of the Establishment Clause. You are establishing a religion. And so Justice Thomas, the
There's
court...
a bit of mental acrobatics there, I would have thought.
Yeah. And if I tell you the full story about the Cleveland schools, I mean, the public schools, 25 of the buildings had been condemned, yet 3 years later, students were still in them. The statistics are in the book, but like 9% were reading and doing math at grade level. I mean, we were having real problems in these schools. And when the parents used the vouchers, they looked to go to the best schools. And at the time, in the region, the best private schools were the Catholic schools. Yeah. So a lot of them were using it to go to Catholic schools, even though a lot of them weren't Catholic themselves. And they were doing it because they wanted to get their kids into a safe environment with a great education and give their kids a chance. And so what Justice Thomas said is the Establishment Clause, as originally understood, did not bar parents from making this choice. Yeah. And he pointed out that the people deciding that they shouldn't be allowed to make the choice. In other words, the people, the teachers' unions, all those people fighting against the choice weren't sending their own kids to these schools, these failing
Always
schools.
Always the case, isn't it?
And so that was the constitutional question. And for a long time, the Supreme Court said that things like that were unconstitutional. This is kind of more activism, right? And what Justice Thomas said is, no, the founders never would have understood a parental choice as establishing a state or federal religion. That is just a perverse interpretation of the Constitution. But the fascinating thing he pointed out is he went through the original meaning, but then he went through the promise of one of our great decisions, Brown versus Board of Education, and said the promise of Brown, the reason Brown was so important was desegregation, of course, but it was also because everyone recognized that education means emancipation, to quote Frederick Douglass. And so that's how he got to that, to go back to the very beginning of your question. And that the only way these kids were going to truly have a chance is if they got an education.
I mean, continuing the theme of education, of course, a more recent case has been around universities using racial preferences to decide who is admitted to the university or not. And this is...
That's chapter 3.
Yeah, great. And well, we'll certainly put where you can get the book in the show notes. And I know it's available on Amazon here in Australia, so yes, easily available. But this policy of, it was a lot of Ivy League universities, wasn't it, who were saying we want students from this ethnic group or minority group, but actually it was disadvantaging some other minority groups like Asian Americans.
It was disadvantaging Asian Americans and white Americans and others, but...
And the court rules against this. I mean, this is quite a massive decision, and of course this is something that Justice Thomas has felt very strongly about throughout his career. I think it's called the capstone of his career.
Yeah, in some ways, yes. I mean, the capstone of his career is probably the influence he's had on originalism becoming prevalent in the courts again. I think he would say that's the capstone. But I think in the affirmative action case, he felt very strongly, and his opinion itself in Students for Fair Admission is worth reading. And he points out that, again, he calls them the cognoscenti, the elites. And he says the elites have a view, they want to get their friends' kids in, basically. And I'm surmising and probably butchering what he said, but they're getting their friends' kids in. And so the people who are benefiting from this are rich minorities at the expense of poor minorities, poor whites, poor Asians, poor others. And he points out that the number one school in America at moving people from the lower class to the middle class is historically Black Xavier. And so if you think about that, you have a historically Black college that under many views would be improper to have. And yet that is the number one school at moving people out. Not Harvard, not Yale, where they were taking, as the New York Times, I think, has recently reported, most of the people benefiting from affirmative action weren't the poor and downtrodden. It was the rich and elites. And so, and the other thing Justice Thomas pointed out is that we have this program in America where legacy children get a break and are let in. And maybe the biggest fear of the elites is their own kids wouldn't get in if we got rid of affirmative action, since that's also being used for legacy children.
Yeah, well, when you want to find out the reason for something, self-interest is usually right up there at the top, isn't it?
That's right.
Look, there's been, as you said before, an uptick in the number of originalist judges, and the Supreme Court is now more an originalist court than it has been for a long time. Why do you think that is? Is it trends in law schools or in...
No.
I'm...
I think the reality is that I like to think
it's just right.
It's just right. But I think it's also President Trump wanted to appoint originalist judges and made it a priority. But I also think there's something that's caught on because I think we're all learning in some way. Those of us that don't know are learning how to do originalism because the Supreme Court is more originalist today than it ever was. As Justice Kagan said, although she doesn't love when people repeat this, because I think she subsequently said, well, maybe I shouldn't have said it. She said, we're all originalists now. There's been since Justice Scalia really started pushing textualism and originalism, there's no question we are all textualists now. And that means we interpret statutes consistent with the meaning. We don't ignore the text as we used to do, as Justice Scalia pointed out. And I think the same is true with the Constitution now. I think all of my colleagues understand the importance of trying to understand the text.
Well, thank you so much for joining me today on Afternoon Light. This has been absolutely fascinating. Quite a different podcast topic from our normal Menzies era history, but I think one that our listeners will really, really value. And it's always important to hear the comparative experiences we have with our friends across the Pacific. So Thanks for joining me.
Well, thank you for having me. It's been a real treat.
That's it for this week's episode of Afternoon Light, the podcast of the Robert Menzies Institute. Please make sure to subscribe and catch up on our latest online content on our website or on Twitter, LinkedIn or Facebook.